Hello students, today we are going to discuss a very important topic which is relationship of economics and law. Myself Amit Kumar Singh, I am assistant professor in the School of Law, Sushant University, dealing with couple of humanities subjects in BLLB and BBLLB. So I try to bring your attention toward this very vital topic, what is relationship of economics and law. So as we all know that there is huge material available related to economics or with the subject of economics but separately. But when it comes to study the area, the boundaries, merging the areas of economics and law, you will find that there is a huge dearth of library resources, textbook or books. But these both subjects like economics and law are having a close connection. So I want to quote Justice Brandeis, what he remarked about the relationship of economics and humanities with this discipline of law. A lawyer who has not studied economics and humanities is very apt to become a public enemy. What we were discussing, that the material which encompasses merged boundaries of economics and law are very narrow, very scarce. And again, when we go to understand what is the proper definition of law and what is the definition of law and how law has to be interpreted, the definition usually we proposes is in a very, very narrow and parochial manner. It is designed to train a student just to be an advocate, or you can say just to limit his potentials only to the sections and the clauses of the legal discipline. So, as we continue, what are the legal principles coming? From where are the legal principles are coming? So, as we all know, economic facts comes first. They are the bedrock on which the legal principles are formulated. And as French economist Guide remarked, that economics and law are sister sciences. Any differentiation is a matter of convenience, or you can say it's an invariably artificially designed. One should not be so myopic in understanding law and economics or other relationships with the humanities, with law in a very narrow and parochial manner. Discussing that both law and humanities including economics are sister sciences. So, to do one's duty may be a ethical conception. To exercise one's rights is a legal question. To whom ought it to be belong is a boundary line between the law and economics. So, the boundaries are not always static. They keeps on fluctuating. They keeps on interacting. Now we move forward. But what are the common ground of economics and law? So as we all know, legal principles are not the whims or the passing fancies of some people sitting in a boardroom, or they are not coming from, you can say, a closed room discussion. Rather, they are the development of social life, historical evolution, and our moral and ideal typical sentiments. So, economic notions related to ownership, disposition, and enjoyment of economic goods are embodied in legal principles. So, now we try to simplify this proposition or this notion, that how economic notions are usually converts into legal principle. So we take the example of law of primogeniture, where the succession rights vests in the eldest child. When we travel back in medieval ages, when there was a kind of landlord system, law of primogeniture was in practice. But now, when we encounters law in modern times, individual rights and the individual ownership on the property has been recognized. This is due to the change economic orientation, and now law of primogeniture has been subsided by the transfer of property vested in individual rights. Again, there is dynamic evolution of legal principles in India pre and post globalization. What we can observe that pre globalization there was a kind of property rights, or there were a kind of inclination towards socialism, so the laws were inclined to fulfill that orientation. But now, as we are moving towards a more relatively open economy, the laws are also quite flexible and changing. So now we should move towards another important aspect of relationship between law and economics, and that is that not all the time economic facts are petrified or converted into legal principles. Suppose in economics you may believe, or the discipline of economics may believe in the notion of absolute liability, but law believes in different interests or different liabilities in production system. And again, economic theory may believe in unity of interest in land and personality, but here in the field of law they believe in different aspects of land and personality, maybe in form of title, maybe in form of possession, or maybe in form of present, or some titles may be mature in future. Again, the economic theory may believe cooperation and circulation of goods freely, but this will not going to hamper the legal idea or legal principle of creating a kind of contract, a kind of different laws to regulate economic endeavors. So now what we can summarize out of all this, that the economic facts and social evolution are the raw material of law, but not all the time. Essentially, the economic facts may be mature into legal principles, but this may be understood that the economic principles gradually persists and mature into legal principles, not wholly but maybe selectively. Now again, a very important area where law and economic system has a common boundary. So as we all know, any economic activity has to be performed when there is order. But this order is impaired, or this order has been in the clutches of some unusual, unpredictable feature, which is future. Future may derail our activities, our economic activities. The one aspect is natural calamities, and the second activity is any of the endeavors people try to venture into depends on the non-intervention of many other human beings. So the first one, which is natural calamities, can be controlled, can be anticipated with the help of technology. But the human endeavors which are non-controllable, which are non-predictable, has to be regularized, and for that law has to play a very important role. Contract acts are there, and contractual ambience gives the economic activities to be in order. Again, if an economic system wants to pursue a planned economy, that kind of institutional and legal framework is required. But if we try to forge and try to promote laissez-faire, again, the conditions which make laissez-faire or perfect competition feasible are required. So there shall be no monopolies. Again, a very much conducive legal institutional framework is required. So what we see that to bring economic ideologies into legal framework, we are having contract acts, we are having tort, we are having negotiable instrument act, and again jurisprudence. So the jurisprudence should rather be understood economically, not politically. What we have discussed till now, that first we have to forget the habit of segregating the social sciences and law. Second thing, any segregation or any classification may be non-scientific, but still if the disciplines or different disciplines have been seen a maturity, they should be respected, but the ultimate object of all the subjects which is common should not be forget. Second thing, when we summarize our discussion, our analysis, what is the relationship of economics and law, we should remember the key findings. First thing, the study of law without the knowledge of other social sciences like political theory, sociology, and economics, etc., is incomplete. In any law curriculum, the second one is very important, what we foresee and what we are trying to introduce in Sushant University at School of Law. In any law curriculum, the study of economics and law and other interaction is increasingly found necessary. Thank you.